Everybody for joining me this afternoon. My name is Philip Siegel, and I'll be speaking on the Department of Labor's new overtime rule. Just a brief introduction for those of you not familiar with me. I'm a partner with the firm Hendrick, Phillips, Salzman and Flatt. We are a construction boutique law firm based out of Atlanta, Georgia, and my practice within our firm focuses on the labor and employment component of our clients' businesses. And labor and employment law has been a particularly hot topic with a lot of the executive orders that the President has issued and the regulatory regulations that have come out of the various arms of our government. And here we're here to talk about this afternoon the Department of Labor's new overtime rule. And I'll tell you, just coming into the office this morning following last night's election, I've gotten several emails and phone calls just over the last few hours asking me, you know, are these Department of Labor new overtime regulations going to be going forward in light of the Mr. Trump winning the election, a Republican coming into the Oval Office? And, you know, I can't predict the future, but while there's been a lot administratively and with the executive orders that the President has issued, and these regulations, including the overtime one, this is not at the top of the list among those that I think will be repealed or never enacted. This new overtime rule comes into play December 1, and certainly nothing, while there is litigation pending and there are business groups making an attempt to have enforcement of the new rule delayed or to knock it out entirely, I do very much expect this new rule to go forward. So the objective here is to make everybody familiar with the new rule and really address how it will be applying to your company. And this new overtime rule, just to bring it into the slides, the new overtime rule speaks to, and what we're really concerned about are the employees that you are currently treating as exempt from overtime pay. And your exempt employees, or people that you're correctly treating as exempt, are generally going to fall into one of what is referred to under the law as a white-collar exemption. And the PowerPoint, the screen I've got up, just explains that the various white-collar exemptions, the three most common, the executive exemption, the administrative exemption, and the highly compensated employee exemption, I'll be diving into in detail. But I did also want to note that when I speak about white-collar exemptions, other exemptions that may not be so prevalent in the construction industry but are out there, and I wanted to make you aware of it, are the professional exemption, the computer professional exemption, and then the outside sales exemption. And actually, the outside sales exemption is maybe more prevalent in the construction industry than I first gave thought to, and I do expand on that in a couple slides as we move forward. But as we are classifying people as exempt, and as I transition to what the new rule is, I want to just make everybody aware that when you are deciding whether an employee is exempt from overtime pay or non-exempt, in which case the non-exempt employee, when they work over 40 hours during a work week, they're getting time and a half. In order to properly classify someone as exempt from overtime pay, they need to pass a number of tests. There's the job duties test, the salary basis test, and the salary level test. And that's the case for most of these exemptions. As you'll hear me soon say, the outside sales exemption, there's an exception there as it concerns the salary basis test. But what the new rule addresses is only the salary level test. And what I've got here up on the screen is the new rule in a nutshell. Where currently the salary level requirement to classify someone as exempt is that the employee needs to earn at least a salary of $455 a week. That equates to $23,660 annually. That's the rule today. As of December 1, however, that salary level jumps from the $455 per week to $913 per week. That equates to $47,476, as I've noted on the screen. More than double what the salary level is under today's rules. The next bullet point just speaks to the HCE. HCE is the highly compensated employee exemption. The highly compensated employee has a different salary level test than the other white-collar exemptions. For the highly compensated employee, in order to pass the salary level test, under today's rule, the salary requirement is $100,000. Moving forward after December 1st, that number jumps to $134,000 $134,004, and all of this becomes effective December 1st, 2016. So as we go forward with the presentation, the employee that you really need to be concerned about is the individual who is currently earning more than the $455 per week salary level test under today's law, but less than the $913 per week that'll be the new salary level test as of December 1. What can you do with those employees? And I'll be speaking on that as we conclude. I'll give you some other options. But before we come back to the new rule, I did want to make a note to say that, again, the salary level test is just one of the 3 tests you need to clear and pass before you're properly classifying someone as exempt. And when the new overtime rules were first announced and the government solicited comments on the proposed rule, there was much discussion about whether the job duties tests for these white-collar exemptions was subject to change. And in the end, the new rule does not at all change what the job duties tests for each of these exemptions. And I wanted to run through what those job duties tests for each of the more common exemptions applicable to roofing contractors. And I've got up on the screen the executive exemption. And there are 3 components that an individual must meet in order to be passing the job duties tests as we go through and are making a determination whether an individual is properly classified as exempt. And for the executive exemption, the first component of the test is that the individual's primary duty must be managing either the enterprise or a customarily recognized department or a subdivision of the enterprise. And it may be that it's just a crew leader, someone who is, when we talk about a recognized department or subdivision of the enterprise, it might be that you have the argument that the individual's primary duty is to lead a crew, qualifies as a subdivision of the enterprise. Certainly maybe a stronger argument is the individual heads your entire commercial department or your service department. They're meeting this first component of the executive exemption test, job duties test. The second bullet point notes that this person that we're analyzing under the job duties test for the executive exemption, they must be customarily and regularly directing the work of at least 2 or more other full-time employees or their equivalent. Well, real quickly, or their equivalent, that refers to, under the law, you would have maybe 4 part-time employees equaling 2 full-time employees. And that's what we talk about that's what we mean when we speak about the equivalent. Where companies tend to get hung up on the job duties test here is the individual that is charged with supervisory authority, but really this individual is only performing a quality control function for your company, and that they're going out to your job sites where you don't have employees out at the job sites. You maybe have independent contractors, individuals that you're issuing a 1099 to. And it's this person's job responsibility to go out there and make sure the independent contractors are doing the work and doing it right. And I've had the case where the argument made by the client was, you know, this person qualifies for the executive exemption, they're a manager, they're managing all these work sites, and they're overseeing the work of the guys doing the work. Well, when you dig into that, you learn that no, the people that are being directed aren't employees. That is a legal term. They're not employees, but they're independent contractors. You're going to lose on this component of the job duties test for the executive exemption. But if it's your typical crew leader that's customarily and regularly directing the work of 2 or more full-time employees that are actually your employees doing the work, then you have the facts to argue you're meeting this component of the job duties test for the executive exemption. The last bullet point that also, again, we need to hit all 3 of these is the individual that manages a recognized department or subdivision of your company, customarily and regularly directs the work of at least 2 or more full-time employees or their equivalent, must also have authority to hire or fire other employees, or if they don't have that authority in a vacuum by themselves to do that, that at least their suggestions or recommendations as it concerns that kind of thing is given particular weight, pulled right from the slide here I've got up on the screen. And you think about the individual that, again, is heading a crew on maybe it's a project out of state, and they're directing the work. Your crew is 2 or more full-time employees, and then while they're out there, they actually have authority to hire walk-ups or fire people that aren't performing on the site. Well, all of a sudden you've got the individual that at least meets the job duties test of the executive exemption. Let me cover the administrative exemption very quickly. Again, the job duties test I've got up on the screen. This isn't changing after December 1. But the individual that doesn't qualify for the executive exemption may, in fact, qualify for the administrative exemption. It's a little tougher to qualify for the administrative exemption because it's the 2 components I've got up on your screen here are more prone more open to interpretation, as opposed to whether someone is directing the work of 2 or more full-time employees. You can look at that; it can be black and white, or a lot clearer than determining the test results under the administrative exemption here. But for the administrative exemption, again, here are the 2 components, and this comes right from the regulation, and it's that the primary duty of the employee must be the performance of office or non-manual work. These are not your laborers, but the work must be directly related to the management or general business operations of the employer or your customers. And this primary duty also includes the exercise of discretion and independent judgment with matters of significance. So you can consider maybe the project manager that doesn't qualify for the executive exemption because either he's not customarily in directing the work of 2 or more full-time employees, or that project manager doesn't have any authority to hire or fire, and their opinion isn't giving any particular weight. This person may, in fact, qualify for the administrative exemption. I tend to think of your controllers or in your accounting functions, performing accounting functions, or perhaps an estimator, someone that is, again, performing office non-manual work, and with a bid or an estimate, clearly your hope is you can make the argument that they're exercising some discretion and independent judgment with matters of significance. Now, on that point, when we talk about an estimator, it's not that this second component of the job duties test for the administrative exemption requires that that person have no oversight. In other words, this second component of the administrative exemption job duties test, you can have someone that qualifies for that meets this component, but their work may be reviewed. The question in that situation is going to be, what's the level of review, and does it cross a line where the argument could be made, really, the person whose work is being reviewed, the level of review is of such detail that the person whose work is being reviewed isn't really exercising any discretion or independent judgment. But the point I'm making is there can be some review to make sure, for example, sticking with my example, the estimator, that there's not a math error. I mean, that would not be something that would disqualify an estimator from falling within the administrative exemption. Okay. In terms of questions, there is the bar up on the right-hand side of your screen. I will look to the questions as we conclude and before I hang up, so I'll make sure to address any questions that come in. Certainly, you can ask the question, and I'll get to it when we conclude. So this slide speaks to the highly compensated employee exemption, and I want to just recap that for this exemption, the salary level test is unique. It's not the $913 per week, but it's an annual salary of $134,004. That's up from what is today a $100,000 salary level requirement for the highly compensated employee exemption. One thing before I get to the job duties test for the highly compensated employee, and it's the second bullet point. While the highly compensated employee must earn over the course of the year at least $134,004 to qualify for the exemption, and you look at that at the end of the year, did this employee earn the $134,000 over the course of the year to qualify, or pass the salary level test for the highly compensated employee exemption. The other component of this exemption is that the highly compensated employee must earn at least $913 per week. That is to say, they're earning $913 per week, and that's not at all dependent on any production bonus or commissions or any other form of compensation that eventually gets them at the end of the year to the $134,000. Because again, that $913 per week is only the $47,000 and change per year. The highly compensated employee, in an extreme example, may only, well, to properly meet the salary level test, needs to be earning the $913 per week. At the end of the year, if they don't qualify for any other exemption like the executive exemption or the administrative exemption, and why wouldn't they qualify? They wouldn't qualify because they're failing the job duties tests. So the individual that doesn't qualify for the executive exemption because they're not meeting all three components of that test, and the individual that doesn't qualify for the administrative exemption because they're not meeting the two components of the job duties test for that exemption, you're left wondering, well, is this person exempt from overtime? They're making over the $913 per week. And the point I'm making as I get through this slide is that there is the highly compensated employee exemption. And the job duties test for the highly compensated employee, you only need to be looking at whether they perform one of the duties from any other of the white-collar exemptions. So the individual that may only be, I'll stick with the individual who maybe is customarily and regularly directing the work of two or more full-time employees. That's one of the components of the job duties test for the executive exemption. But that person also does not have any authority to hire or fire, and their opinion is not even consulted when it comes to hiring and firing. And moreover, this person, while they're directing the work of two or more full-time employees, they actually also are not, in doing that, the argument cannot be made that they're exercising independent discretion with regard to matters of significance. So they're not qualifying for the administrative exemption. But because in this example, I told you at the beginning, this guy that we're talking about does direct the work of two or more full-time employees, well, then you've grabbed onto one component of either the executive exemption or the administrative exemption. It happens to be in this example, I'm grabbing onto one within the executive exemption job test. Well, then you've met the job duties test for the highly compensated employee. But you need to pass that salary level test for the highly compensated employee. And the trade-off for only having to look at one of the components of the job duties test for the executive exemption or the administrative exemption is that the salary level needs to be higher. And that's where I jump to the $134,000 number. And that's where the number needs to be at the end of the year. But through the course of the year, looking at it on a week-to-week basis, this person, to qualify for the highly compensated employee exemption, must be earning at least $913 per week. Again, the balance between the $47,000, which is the $913 per week, and the $134,000, that could be made up in bonuses and commissions, and you can do that at the end of the year and the last day of the year to qualify someone for the highly compensated employee exemption. But this is I've gotten a lot of questions about the highly compensated employee exemption, and specifically the job duties component. People tend to get confused. And it's, again, let me go back in the slides. The executive exemption, again, if you're going to qualify someone for the executive exemption, they need to be hitting on all three of these components. And they need to be making at least $913 per week. If they're hitting all three of these components, you don't need to be worried about paying someone $134,000. You only need to be worrying about the $134,000 for the employee you're looking to qualify as exempt, but doesn't meet all three of these tests, or doesn't meet all two of the administrative exemption job duties tests, which I have on your screen. But you can point to at least one of these 5 job duties over these 2 screens, the executive exemption and the administrative exemption, you can point to one of those and says, hey, my guy does that, and if you can do that and pay them at least $134,000, now you've qualified this person for the highly compensated employee exemption. And the last point I want to make on this exemption is the third one there. This is never going to apply to the guy who's actually working side by side with your laborers, because that person is actually doing manual work, and that in and of itself is going to disqualify this person from the highly compensated employee exemption. And I don't care that they're making $134,000, it's that they're failing the job duties test. Their primary duty in this example is manual work. While I keep referring to primary duty, one of the discussions that was held when the proposed rule came out was actually adding percentages to help companies decide, what is the primary duty. There was a push that, well, in order for a job responsibility or job duty to be primary, it needs to take up at least 50% of the employee's time. That was what was being discussed and proposed. That is not the rule, and it may be that you have an individual that you're arguing about what their primary duty is, but that primary duty may only be 20% of their work week. It's going to be a fact-intensive inquiry. The point I'm making is it's not black and white. It's not that you need to hit a certain percentage of time threshold to qualify someone's duties or responsibilities as primary. Okay, let me move off the highly compensated employee and talk a minute about salary before I jump back to the new rule and the salary level test. So we just got done, just to recap what we've done so far. I first discussed, there are these white-collar exemptions, and in order to properly classify someone as exempt, you need to pass the job duties test, you need to pass the salary basis test, and you need to pass the salary level test. And I've explained that the new rule only addresses the salary level test. I'm going to be coming back to that. But here I want to talk about the salary basis test. The first point I want to make is, as we go through this component of whether someone is properly classified as exempt, is that it doesn't apply to someone that qualifies for the outside sales exemption. And I do have a couple slides coming out that speak about the person and what's necessary to qualify them for outside sales exemption. But the person who is classified correctly in outside sales, you don't have to pay them a salary. That person could be 100% commission. I'll come back to that. But the salary basis, a salary, there's no science to it. I mean, it's a predetermined amount of compensation, and it cannot be subject to reduction based on the quality or the quantity of work performed. That is to say, the individual that you're looking to classify as exempt, if they perform, well, this is the rule, if they perform any work during the week, they're owed their full salary for the week. If, on the other hand, you have an individual that takes a full week off, doesn't do any work during the week, an exempt individual that's earning a salary, you can dock that person's salary for that full week missed. The exception I've got up on the screen is if the full week is missed because the business has been closed, management's closed the business, then in that instance, the law would say the employee is available to work, but the employer has made work unavailable. If you as the company close the office for the week, you're making work under the guise of the law. You're making work unavailable. Your salaried employees are still earning their salary for that week. I'll just add, the non-exempt employees, the people who are not qualifying for any of these exemptions, the people that are earning time and a half when they work more than 40 hours, where they're not working, they're not getting paid. I'll just add that 2 cents. So, an hourly paid non-exempt employee is only earning wages when they're actually working. So with regard to the office closure, for whatever reasons it's closed, the non-exempt employee isn't getting paid. So I'm coming back. We're talking about the exempt employee and having to make sure you're paying a salary, using that term, as it's defined under the law. And the key components are the individual, again, the rule is the individual is earning their salary when they're available to work and they're performing any work during the week. They're getting their full salary for the week. Well, the question comes, Philip, is it that I'm never allowed to make a deduction from a salaried employee's pay? And well, you are allowed to make certain deductions. I've got them up on the screen. I'll run through them here real quickly in a second. But if you're making an improper deduction from an individual that's earning a salary, in the eyes of the Department of Labor and the courts, that person's no longer earning a salary. I mean, again, a salary, when I'm throwing the term around, it's a legal term. And if you make improper deductions from a salary, then you're really not paying a salary, and you'll fail the salary basis test. So what are the permissible deductions you can make from an exempt salaried employee's pay? First one talks about an absence of 1 or more full days for personal reasons other than sickness or disability. Think about the individual. Let's say, well, sticking with, I just got done speaking about the office closure, and what I gave you was the example where you've closed the office for the week. Well, what if your business is open, but here we're about to enter the winter months, business is open, but a storm comes through, and you have a salaried exempt employee that is saying they can't get to work because of the weather, but business is open, your shop is open. Well, what then? Well, the exempt salaried employee that misses a full day of work in that instance, and again, I'm giving you an example involving weather, the law would say that's a missed day for personal reasons other than sickness or disability. You could dock that exempt salaried employee's pay 1 full day. It's got to be a full day. If they can't get out of their driveway in the morning because of the ice, and the ice melts, and they're coming in at about 11:30 in the morning, that exempt salaried employee is getting their full salary for the day. It's got to be, as we cover this first bullet point, of 1 or more full days. A partial day absence does not allow you to deduct from the salary. So the individual that's leaving work early to attend a parent-teacher conference or a school play, you cannot make a deduction from that employee's salary without jeopardizing the exempt status of that employee. Second bullet point speaks to the full day or 1 or more full day absence where it is related to a sickness or disability. It's not a personal reason. Person's calling in sick. Again, it's got to be a full day. Anything less than a full day, you can't make the deduction. But if it is a full day and you want to make the deduction, you can only make that full day deduction from the salaried exempt employee if you have a plan or policy in place where employees can earn paid leave time, paid sick time. It doesn't necessarily have to be paid sick leave. You can have a paid leave policy that can be used for whatever purpose, including sickness, in which case, if you've got that policy out there, it's in writing, you can make a full day deduction from an exempt salaried employee's pay for that full day absence. And it doesn't matter. The law is very clear on this. It's as long as you have the policy in place. So the exempt salaried employee that is taking a full day off for sickness or disability and maybe hasn't yet earned paid leave time to offset the lost wages doesn't matter. Or maybe they had paid leave, but they've exhausted it all, so they've got nothing left in their paid leave bank, and now they want to take another full day off because of a sickness. It doesn't matter that they've exhausted all their leave in their bank. What's key is that you offer the policy. And the individual that has spent their paid leave and needs another day off, you can dock that employee's pay for a full day worth of their salary without jeopardizing the exemption. Third bullet point, offsetting jury or witness fees or military pay. That is, if someone serves jury duty, they get $25. You can hold $25 of their salary. Next component, penalties for infractions of safety rules of major significance. This is it's got to be an infraction of a safety rule. I had the question actually within the last couple of weeks. A company wants to charge its salaried exempt employees with a deductible on its auto insurance policy if the individual is found responsible for a car accident with the company vehicle. And that, unless the argument, and I don't think it can be, or it's not a very strong one, unless you can argue it's infraction of a safety rule, that would be an improper deduction. And in fact, there is a Department of Labor opinion letter out there discussing an analogous situation where there's damage to equipment. You're just not going to be allowed to make that deduction from an exempt salaried employee's pay without jeopardizing the exempt status of the employee. But if you're dealing with a real safety rule, a fall protection violation, and you want to administer a penalty, check state laws to make sure no state law gets in the way, but otherwise under federal law, you would be able to make that deduction from a salaried exempt employee's pay without jeopardizing the exemption. Similarly, the next bullet point just speaks to the unpaid disciplinary suspension. Again, the key is it's got to be in full day increment. The individual that is there at any part of the day, you can't make the deduction. But if we're dealing with a disciplinary suspension for a violation of workplace conduct rules, and it's a one or more full day suspension, you can make that an unpaid suspension and deduct from the individual's salary. The last point just notes that if the individual we're discussing is commencing employment midweek or ending employment midweek, you can prorate the person's salary for that initial and last week of employment. So these are the only permitted deductions you can make from a salaried employee's pay. And I've just got some examples here on what are common improper deductions, some of which I have already just discussed in passing here. The third one just notes you can have the individual missing a full day, 2 full days for sickness or disability, but if you don't have a paid leave policy, you can't make the deduction from the individual's pay. There is one way to save yourself. Well, again, this is if you are making that improper deduction, the legal argument is you're not paying a salary, so the individual fails the salary basis test. They may pass the job duties test for one of these exemptions, but they're failing the salary basis test because you've made an improper deduction. And the look-back period, when we're dealing with loss of exemption, where there is potential exposure, is the person who's regularly worked over 40 hours. Now you've made the improper deduction, and they're claiming that consequently they're non-exempt and they're looking to get paid overtime for all the weeks that they worked over 40. And the slide notes here that the look-back period is 2 years. It can be 3 years if the violation is considered willful. If you made a willful violation, knew what you were doing, then you're in a little bit bigger trouble because the look-back period is an extra year. If you do make an improper deduction, while the rule does recognize that the consequences are severe, what I've noted up on the screen is that there is a safe harbor that where even though you've made an improper deduction, you can in fact save yourself from, let me go back a slide, I want to make sure. Yeah, let me stick with this before I move on to the next slide. So what this slide says is, yeah, the exposure exists 2 or 3 years back. The other point I want to make is it's for all employees affected by the practice. That is to say that if you've got a project manager that you're qualifying for one of these exemptions and you've made an improper deduction, the law and the way it reads is that you've jeopardized the exempt status of not only the project manager who suffered the deduction, but all project managers across your company. Even though the improper deduction was made only once, the way the rule reads is the exemption is lost for the entire class of employees. So understanding that that consequence is severe, the rule offers this safe harbor. And if you have a clearly communicated policy that discusses prohibiting improper deduction, provides a mechanism by which employees can raise a complaint regarding an improper deduction, where you find something's been done improperly, you're providing immediate reimbursement and letting people know that, hey, we're going to comply in the future, we're fixing this. Then if that policy is out there communicated to your employees either via poster or maybe an employee handbook, then in that instance you will be absolved of the most dire consequence, which is that exemption being lost for the entire class of employees. So it's just a simple, I offer it to our clients, safe harbor improper deduction policy that saves you from the most dire of consequences when you've made an improper deduction from one salaried exempt employee's pay. Okay, I said I'd mention the outside sales exemption. Just because I know a lot of companies, the more I'm out there giving this presentation, I'm being asked about outside sales folks. And I wanted to note it's the outside salesperson that isn't earning any salary. These Attendees listening to the seminar tend to hear that the salary basis test, and they think, I have employees I'm treating as exempt, I'm not paying any salary. Well, if they qualify for the outside sales exemption, you're going to be okay. The key here is the job duties test. And the individual that's qualifying for the outside sales exemption, it's their primary duty must be making sales or obtaining orders or contracts for services for which monies are going to be paid by your client or customer. And then the second component is very key. The person must be customarily and regularly engaged away from your place or places of business. If they're at a desk all day in your principal office, they're not going to qualify for this exemption. So I want to expand a little bit about primary duty and customarily and regularly. And again, there's no percentage here. It's just like I've got up on the screen, going into the regulations, principal, main, major, or most important duty. It's not a function of how much time they spend performing that duty. It may only be 20% of their work week, but it happens to be the most important thing they do. That person's going to qualify, or that's primary. That person's primary duty. Customarily and regularly, just again, how is it defined? It doesn't get much clearer in the definition, but it's greater than occasional. It doesn't have to be constant. I think that's the important point. Expanding on that a little bit, consider work normally performed every work week and not your isolated or one-time task, kind of common sense. And again, I'm noting not a percentage test. These overtime rules did get revised now almost 10 years ago. Before the last revision, almost 10 years ago, there was a percentage test that did apply, and that went away when the overtime regulations were last addressed. I've said that a couple times now. What is it again with the outside sales? To be engaged away from the employer's places of business. It's your estimator who's going out to the job, looking at the site, and the argument you're making, or hopefully making, when you're qualifying for someone for this exemption is they're making the sale when they're at the site, looking at the roof, meeting with the customer. It can be door-to-door too. Residential roofing, door-to-door sales are certainly going to qualify here as well. And I'm just noting it doesn't have to be absolute. With this last bullet point, they can do other activities other than just selling, but those activities need to be actually incidental to the sale. Think about computer paperwork that needs to be done to effectuate the sale. If that's done as incidental activity to support their own sales, you're not jeopardizing the exemption for the outside salesperson. Again, this is the job duties test for the outside salesperson. Think about the person making 100% commissions, not earning a salary. You can still avoid paying that person overtime if they fit within this outside sales exemption. Okay, back to the new overtime rule and the salary level component. Again, it's the salary level test, and this slide just explains, I've explained to you already, the salary level test, and throw out the outside sales exemption we just got talking about. I'm talking about the people you qualify as executive under the executive exemption, or you qualify under the administrative exemption. And in each case, that new salary level as of December 1 is the $913 per week. Where is the $913 coming from? Well, the way the regulation reads, it doesn't say $913. It says the salary level is going to be set at what is the 40th percentile of the weekly earnings for full-time salaried workers in the lowest wage census region. And coming out of our last census, the lowest wage region is here where I am in the South. And the 40th percentile of weekly earnings of full-time salary workers here in the South is $913 per week. That's where the number is coming from. The highly compensated employee, where their salary level is jumping from $100,000 to the $134,004, where's the $134 coming from? The regulation reads, that happens to be the 90th percentile of the annualized earning of full-time salary workers on a national basis. We're not looking at any region. We're looking at just full-time salary workers. What's the 90th percentile? What's the earnings of the person at the 90th percentile? And that's your $134,004. Now, this next slide is a really important part of the new rule. It's new. It doesn't exist as we speak today, but it's coming into play on December 1. And this part of the new rule basically says that will consider the individual that's your executive or your administrative exempt employee needs to earn at least the $913 per week. The new law says that you can meet 10% of that salary level requirement in the form of earned bonuses, commissions, or payments, non-discretionary bonuses. That is, dollars that you have to pay if the employee qualifies. The employee could sue you for these bonuses and win the lawsuit because they've done what's necessary to qualify, and at that point you've got no discretion, you need to pay it. And what the new law says is you can meet 10% of the salary level test in the form of this non-discretionary bonus. So consider, just working through the slide here, that if you did the math, if you did the the way the law would read is that we are on a 52-week calendar year. Each quarter is 13 weeks. If you multiplied the 913 times 13 weeks, it would come up to $11,869. And what this new component, this new part of the rule, or excuse me, this part of the new rule that's brand new, says that you can meet 10% of that, or $1,186.90 can be paid every quarter in the form of a non-discretionary bonus to help you meet that salary level requirement. Now, the payments, these bonuses, these non-discretionary bonuses, need to be paid at least quarterly. And if you're looking to take full advantage of this component of the new rule, you're not having to pay $913 per week per se, but you're only having to pay 90% of what's $913 per week. And again, that last 10%, if you're hoping to keep the person qualified as exempt, the last 10% is paid no later than the end of the quarter. So here I give you some more numbers. Again, salary requirement $913 per week. If you calculate that times 13, this person to qualify for the exemption is earning $11,869 for the quarter at a rate of $913 per week. Now, in the second bullet point, I'm suggesting you want to take full advantage of this 10% non-discretionary bonus, part of the new rule. So during the 13-week quarter, at the end of every week, all you're paying is $822 per week. That's an approximation. I've taken 10% off the $913. It leaves you with $822. That amounts to, at the end of the quarter, $10,686. Now we're at the end of the quarter. If you're, and again, I've already said you can pay the bonuses more frequently than quarterly, but you can't do it less frequently than quarterly. So if you're only paying the non-discretionary bonus, consider commissions, non-discretionary bonus at the end of the quarter, well, then for this employee up on the screen, earning $822 a week, you better make sure that their bonus paid at the end of the quarter is at least the $1183, which gets you up to the $11,869 at the end of the quarter. Now, what happens if the individual that you are looking to meet the salary level test using 10% in the form of a non-discretionary bonus? What happens if you get to the end of the 13 weeks and this person just didn't perform as you expected and they're short? The $1183 I just got done telling you needed to pay, let's say the guy, the person only earned $500. Well, you're short $683. And because you're short, this person's failing the salary level test. What can you do about it? Well, the new rule also offers you some relief in this example. And what it says is that you can pay what's the catch-up payment no later than the end of the first pay period, no later than the first pay period following the end of the quarter. So in my example here, I'm telling you, you're waiting to the end of the quarter. You needed to make sure that the employee was paid at least a quarterly bonus, non-discretionary, of $1,183. I just got done telling you this individual we're talking about only earned a non-discretionary bonus of $500. If you're looking to keep that person qualified as exempt, on the first payday following the end of the quarter, you need to pay the person the difference between the $1183 and the $500 they earn. They're getting a free $683 on the first payday following the end of the quarter. Now, the last bullet point on this slide just notes that for highly compensated employees, you don't need to be worried about making the non-discretionary bonus contribution every quarter. For the highly compensated employee, where the salary level test is $134,004, this has always been the case. This is not new with the new rule. The highly compensated employee, the only thing that's changed for that person is the salary levels jumped from 100 to the 134. And so, put another way, and I also told you that the highly compensated employee also needs to be earning a salary of at least $913 per week during the year. And if you get to the end of the year and you see that the person is under $134,000, you can pay the highly compensated employee the catch-up payment at the end of the year to get them. Just in an extreme example, let's consider the person you were hoping to qualify as a highly compensated employee and avoid paying overtime, and they all during the year you're paying them the minimum $913 per week in order to qualify for that exemption, and then you get to the end of the year and this person just had the most awful year, and again I'm just proving a point here, they didn't earn any bonus. Well, then they're getting a free windfall on December 31. If you're looking to keep them as exempt, they're getting the difference between 134 and the 47,000, which is the $913 per week. They're getting that free money in order to keep them qualified as a highly compensated employee. And again, I'm just proving a point there. So that 10% component is a big one. So what can you do? I began the presentation explaining really your focus should be on the individual that doesn't qualify for the highly compensated employee exemption, but is earning more than the more than the $455 per week under today's rule, but less than the $913 per week that'll be effective December 1. I'm going to speak about that here. Well, the first thing I want to say is, as you consider these people, the salary level we're talking about, that $913 per week, set at the 40th percentile in the region earning the lowest amount of wages, now the South. This is going to be updated every 3 years, beginning January 1st, 2020. And there are some predictions out there that when this assumes the new rule is going to survive the change in office here. But if the new rule does survive, in 3 years, the salary level is anticipated to rise to $51,000. And put another way, in 3 years, the 40th percentile, of a salary for the in the lowest wage earning region will be $51,000. That's a prediction. These new rates, when they come out before 2020, they're going to be published well ahead of time for companies to make adjustments, 150 days. And then I know, again, where I started, that there is litigation pending right now. And there's been litigation with anything, really, with everything that this administration's tried to push through on businesses. And in many cases, in most cases, business groups have been successful blocking implementation of these rules. I think about the new, what was the persuader rule. There was a push to have companies identify what they're paying their attorneys to fight unions. Or most recently, you may have heard the new rule proposed for federal contractors who have to identify where they've maybe gotten into trouble with labor violations in the past. It's commonly been referred to as the blacklisting rule. Well, litigation is pending in a court out of Texas. Put the brakes on that regulation that was supposed to be effective October 25th. But here, with the overtime rule, no court has yet to step in and put the brakes on it, and I don't think they will. So what can you do here, getting in anticipation of the new rule? One, the new rule does come with a new wage and hour poster that's available on the Department of Labor's website, www.dol.gov, and that poster actually needed to be in your break room or available to your employees as of August 1. Just an extra 2 cents here. There happens to be a new poster also for the Employee Polygraph Protection Act. Again, all available on the Department of Labor website. But coming back to the individual that's earning between the $455 per week and the $913 per week after December 1, what do you do with that person? Well, I think the first step is to analyze how many hours is that person really working? Because if the individual that's earning a salary of greater than $455 per week, but less than $913 per week, but never works more than 40 hours, you don't have to worry about that person. Why not? Well, under the new rule, because they're not earning $913 per week, they're going to be non-exempt. But if they're never working more than 40 hours, you're never going to have to pay overtime pay. You can continue to pay that person the same salary they've been paying all along. The one difference is, because they're now going to be non-exempt, they are going to be required under the law you are going to be required under the law to maintain payroll records reflecting their hours worked. But from a dollars and cents standpoint, you're going to remain neutral because you'll continue to pay the salary. That's not going to change. And the individual's not working any overtime. There's no financial consequence. The financial consequence would arise with the individual that is over 455, less than 913, and is regularly working over 40 hours. Well, in that situation, if you don't raise the employee's pay to at least the 913 per week, then you are going to be paying time and a half to that individual when they work more than 40 hours. And the fact that you pay them a salary doesn't change that. You're going to have to do some math to figure out what was the employee's regular rate of pay for the week. It's dividing their salary divided by the number of hours that they worked, and that'll tell you, in effect, what that person's hourly rate was for the week. Well, on top of their salary, you're having to multiply half that regular rate of pay we just figured out times all the overtime hours worked, and that person's earning that as additional compensation. Again, they're getting their salary plus half their regular rate of pay times the number of overtime hours worked is on top of their salary as additional wages. And that is what I've just described is your non-exempt salaried employee. And there is such a thing. You can, we're actually, I run into that term. I have companies that unfortunately get into a wage and hour audit, and they say, well, Philip, the person's exempt. And I'm like, okay, well, tell me about what they do. And, well, I pay him a salary. Well, that person that's having that call with me is forgetting there's a job duties test. And they're just focusing on the salary basis test and the salary level test. The non-exempt employee that earns a salary when they work more than 40 hours, they're getting monies on top of their salary. So the option for that person to avoid paying the overtime pay, one option is to raise their salary to keep them exempt. On the other hand, if you're not going to raise their salary, you're necessarily going to be reclassifying them as non-exempt. They're going to have to maintain payroll records. And I just got done, you're going to have to pay them overtime on top of their salary when they work more than 40 hours. The next bullet point speaks about what is something rarely used, and I know some states outlaw it. I know California, not relevant to this call, but is this fluctuating work week method of payment. And I hesitate to even mention it, but I want to give you a full lay of the land. Why do I hesitate to mention it? Because it really only applies with those individuals whose work weeks really do fluctuate above and below 40 hours. You have to, it's fact intensive. And the individual whose work week is fluctuating above and below 40 hours, you're paying them a set salary regardless of how many hours that they work. And as long as it's clear that the salary is intended to cover all hours worked. And if you have the individual that's fluctuating above and below 40 hours per week, there is a method by which you can remain revenue neutral without getting into reclassifying folks. The next option is spread the work. If the individual who's salaried exempt right now you don't want to raise their salary and they're working overtime right now, you might have to reshift job duties and responsibilities so the individual that's earning more than $455, less than $913 per week, and regularly working more than 40 hours, you've arranged job duties and responsibilities so they're no longer working the overtime. You're avoiding the overtime, and then you're back to the first example I gave, which was just the non-exempt employee, happens to be earning a salary, never working any overtime. You don't have to change anything other than the payroll record keeping. And the last bullet point just notes the companies are revisiting their total compensation package. That is, employment benefits may be taking a hit to keep things cost neutral in terms of what the new rules imposing on companies. So that's it on the presentation. I want to work through some the questions here. Let's see, and the first question. Can I increase that size? Nope. If we are a union shop for our workers, do they qualify for this new overtime rule? And the answer is yes. I mean, you cannot contract outside of the requirements of the Fair Labor Standards Act, and employees cannot waive their rights under the Fair Labor Standards Act. You may be bound to a collective bargaining agreement that requires more than what the federal law requires, the federal law requiring only setting forth the minimum requirements, but you cannot get out from treating someone after December 1st as exempt and paying under the executive exemption or the administrative exemption and paying less than the $913 per week. Or for that matter, the highly compensated employee, you cannot contract out of having to pay at least the $134,000. Again, in a nutshell, you cannot contract out of the Fair Labor Standards Act requirements, and employees cannot waive their rights under the Fair Labor Standards Act. I'll stick around for any other questions. I also will make myself available. My contact information follows if you think of some questions after the fact, and I'll also be sending a copy of my PowerPoint to Patsy over at the Northeast Roofing Contractors Association to make that available to all of you. And there being no other questions, I just want to thank you all for listening and offering me the opportunity to educate you on the new overtime rule becoming effective December 1st. Also, if you want, I'm happy to add you to our firm's email blast list. Just shoot me an email. Depending on what happens, once we have the President's inauguration come January, we'll certainly be offering updates on all of the Department of Labor regulations and the executive orders addressing federal contractors that have come out, and we'll talk about what happens with them on and after January 20th. So thank you very much. Thanks for listening.
Thank you very much. Very informative.
Okay, thanks, Patsy. Take care, everybody. Bye-bye.